until the moment we leave the room.
Okay, so strong with the force you are, you will solve this case. Thank you for asking me. My name is Krisztian Kovacs. I'm coming from Hungary, Budapest, and I'm really happy to deliver you this kind of interesting topic of insolvency law. Being involved in a presentation, I think, is very important for you, even to not to sleep. So I would like to ask you, what do you think? Who's of you going to take apart the company is going to be bankrupt, an insolvent one? It's not a hot topic, right? Not really. We always, we should say to our students, there are no bad questions, there are no stupid questions, there are no stupid students as well. But 2 years ago, one of my students just came to my office. Oh, Chris, this is how they call me, the university. Chris, I have a very interesting topic. I already wrote roughly 20 pages. I'm delighted. Oh, and what's your topic? State competitiveness. You know, there are these charts, and they are saying these are important factors. And insolvency law often takes place in these kind of charts. And I'm totally impressed. And what's your topic? It's piece of... Why? Because no one goes to a state to go bankrupt. And okay, there are no stupid questions, there are no stupid students, but I would say a reasonable man would consider this question a stupid question. So, we are not talking about insolvency law because anyone wants to go bankrupt. We are talking about insolvency law because one of your clients may be a creditor to a company which goes bankrupt. This is why it's important to know the rules, even the basics. Before the accession to the European Union, both Poland, Hungary, and other states as well didn't harmonize the law of insolvency. Insolvency law is still a law of national law. No EU-wide, there is no real harmonization, there are no directives, only few regulations according to insolvency matter, only on jurisdiction and on recognition. In the 1980s or maybe 70s, few guys started to complain about, oh, why not unify insolvency law? What do you think? What was the reason why not unify? It's easy. If you want to unify something, what could you do? To ask a guy to present us a better law that we already have, a better one. It means that not our law is the best. We should change it. And if you have to confess in front of several, much more very sophisticated persons that your law is not good enough, you're totally lost. And this is what happens exactly when the guys in the EU want to recast the regulations. They send questionnaires to experts, to scholars. And what happens all the time? What are the problems in your country? According to application of this kind of regulation, directive doesn't really matter. Oh, there is no problem, everything's okay. We are really good students, there are no problems. What happens? Everything remains the same. This is the main problem, implementing or unifying new laws. So, before 2004, there was no multilateral treaty or something like that. Therefore, how should an insolvency, more specifically liquidation, could be recognized by the states. There was no such procedure. It could be mutual recognition, committee, things like that, but there was no clear recognition of liquidation awards. Then, as we joined the European Union, the EC regulation on insolvency procedures became binding for us, both for Poland, both for Hungary. And this insolvency regulation only deal with the matter of jurisdiction, which court may assess the specific insolvency procedure, and if one court finds that it has jurisdiction over this matter, the other courts must recognize this jurisdiction and divided the scheme of liquidation, more specifically liquidation procedures, to two types of procedures. One type of procedure is the main procedure. This is the most important procedure. And the other procedures are the secondary procedures. There are no necessarily be even one secondary procedure. The certain is always the main procedure. The main procedure decides what is the applicable law to ancillary proceedings. For example, this kind of ancillary proceeding is the liability of managers. This is why it's very important, not just to be the first one who decide this matter, but the applicable law, substantive law, depends on the main procedure. The secondary procedures are just to distribute the assets of the insolvent company. Doesn't really matter in this kind of question. The regulation imposed or required the courts dealing with insolvency to cooperate with each other. I know you are so young, younger even than me, and may not have too much cases cross-border, which has cross-border elements. But what do you think? How does this cooperation goes in an everyday life or practice? It goes something like that. So, if you are, let's say, a Hungarian judge, you are dealing with a Hungarian insolvency case. You know there are connections, let's say, in Poland. The company has a subsidiary in Poland. What would you do? How would you approach the Polish judge? You may write an email, but for who? Dear Polish judge, I have an insolvency case there, please cooperate with me. Not really. Or you should ask the official body of your state to get someone to cooperate with. Yeah? Seems to be a nice working scenario, right? For example, in my private practice, we have a very interesting case according to a cartel damage claim, which is consisting around roughly 5 million euros as a claim. One of the claimants, which we represent, got this claim from an assignment, from a contract for an originally damaged person. This guy commenced proceedings against the cartel members, and one of the cartel members sued, or client sued for the declaration of invalidity of the assignment. Because if the assignment were invalid, he's not a claimant. Therefore, the claim shall be dismissed. And till the last year, there was a mandatory requirement in the Hungarian Civil Procedure Code that before the lawsuit, the applicant and the defendant must try to reach an agreement, try to negotiate this kind of matter, try to reach settlement. Why? To avoid the lawsuit itself. It's a mandatory requirement, it was, the claimant of the invalidity claim had its seat, I think, in Holland, in the Netherlands, in the Netherlands. Therefore, he interpreted the Hungarian code that he had no such obligation. Why? Because in the civil procedure code, exactly described, this obligation is for companies. But this not in the Netherlands, in Germany, sorry, in the Germany. This company was an Aktiengesellschaft in Germany. Do you know what is it? Company limited by shares. It's known in all of the European countries. Doesn't really matter. But everyone should know it if you type it to Google, the second one. So, what happened? The court immediately dismissed the claim because the negotiation. Okay, we are in a hurry. I will be brief, I promise. So, the court immediately dismissed the claim. What happened? Well, my client really liked to postpone the proceeding for some reason, doesn't really matter why. Therefore, we, as defendants, appealed against the dismissal of the claim. You know, we just, please sue us, we would really like it. Why? To postpone the proceedings. What happened? To our surprise, the court shared their opinion that the immediate dismissal was illegal because the court had not examined what is the content of Aktiengesellschaft. Is it a company in the sense of Hungarian law? What happened next? The court turned to the Ministry of Justice, then the Hungarian Ministry of Justice turned to the German Ministry of Justice, Federal Ministry of Justice, to ask whether an Aktiengesellschaft is a company. The German Ministry of Justice just responded, yes, the Aktiengesellschaft is a company. Then what happened? The Hungarian court dismissed again the claim because the negotiation was never took place between the two companies. This is something how cooperation works, the everyday life, everyday practice. So, what's the importance of the main or secondary procedures according to liquidations? I already mentioned that the main proceeding decides which substantive law, or let's say personal liability, manager's personal liability, applies. Why is it important? Because the determining factor to decide which one is the main proceeding is the center of the company's main interest. We call it COMI. C-O-M-I. Normally, let's say 90% of the cases, the COMI is situated where the company has its seat, but not always. Because the center of the main interest, where the business judgments to be made, when they're conducting their business, where their managers are. So, where the head is. This is the center of the main interest. And sometimes it's situated in different state than the seat. For example, let's say it's a hypothetical case, which happened in my practice. So, let's imagine that there is a German managing director or managing relatively good factory in Germany. The German factory importing goods from Hungary, raw materials, and then producing something and sell it in Germany. In 2015, it turns out that the company is nearly to be insolvent, let's say, something like that. So in 3 or 3 months, it may become insolvent. But the manager would say, it was my action. Oh. So, what's the business judgment? Well, we are buying our raw materials from Hungary. Labor workforce in Hungary is much cheaper than in Germany. Why not to move our business to Hungary? And they are moving their business. 2 months is enough for them. What happens? They are starting the production in Hungary, and 3 or 6 months later, the company becomes insolvent. And liquidation procedure initiated against the company. Where does the company situated in this scenario? In Hungary. The company really moved to Hungary in this case. So, the center of the main interest, even if the seat is not moved in Hungary, therefore the main proceeding will be initiated in Hungary. And Hungarian substantive law will apply to the case, to the manager's liability. And there are differences between the Hungarian and the German insolvency regime. In Germany, there is a duty to file, so-called duty to file. If the manager, for the manager, it turns out that the company will become insolvent, he or she must file for liquidation. It's a duty. If not, criminal sentence may be awarded for him, so it's a huge problem. But in Hungary, there is no such requirement. Hungary follows the rule in so-called wrongful trading. We doesn't really care if there is an insolvent situation, so long as the manager won't do something nasty, fraud or fraudulent act, something like that. And in this scenario, before the company moved to Hungary, the manager just transferred a small amount of money, 50,000 euros, to his son for some kind of advice. It was a one-page long contract about advisory, about nothing basically. Doesn't really matter. So, what happened? From the perspective of Hungarian law, the manager did something wrong when he foreseen that there will be an insolvent situation. And therefore, according to Hungarian law, he will be personally liable for every impaired loss that the creditor suffered. And personally liable can be sued and must pay this amount of money, but he transferred fraudulently from the company. What's the nasty in the situation? When the manager transferred those amounts of money, he acted under German law. When this rule does not exist and cannot be foreseen, why? Because who decides the transfer of the central main interest to another state? Not the manager. The manager is carrying the task according to this transfer. But who decides? The owners of the company. So, the manager could reasonably foresee what would be the consequence according to German law. But for him, it wasn't foreseeable that he may be liable according to Hungarian law when he transferred the money. But at the end of the day, due to the regulation, the main proceedings were initiated in Hungary, and this manager were personally liable for this fraudulent act in a relatively short term. So this is why it could be important even for you to know the rules and what the center of main interest means. Okay, sorry, I just want to speed up. Yeah, and roughly 2 minutes about the insolvency forum shopping. You know, there is the hard way, there is the easier way, and there is one that you pay your lawyer for. There are 2 ways to move to another country. There is a directive on cross-border merger to just relocate your seat, or you are acting by fact that you are moving your commit to another state. Why is it important? Why it could be important? Because you may know that your company is going to be insolvent, let's say, in 6 months. Because very huge amount of money becomes due, for example, from a credit facility agreement. What would you do? You are searching for a very debtor-friendly state within the EU. Why? Because you moved there, and if you move there, you as a manager would advise it to your owners, the company's owners, oh, we should move to Germany. Why? Is it involves about anything about your personal life? No, it's totally fine, even for you, no. But why not to move to Hungary? No. Because of the personal life? But no, definitely no. It's not the best place for the company and even for you. Why? Because you know that there will be a liquidation, and you have to find the best place for you and for your company to die. You know, all elephants go for the same place to die. Really the same happened before the new regulation, before 2015. And because of that, there is a presumption in the regulation, even if you move your seat to another member state within the EU for 3 months, the commie will be your previous place. Why? To prevent, or trying to prevent, this kind of fraudulent forum shopping. Therefore, you, as a lawyer, you are paid for, what would you advise? Keep your company alive for 4 months after moving your seat to another country. Thank you very much.
Very quickly, I can't help but ask one quick question. You referred at the beginning to the various charts and categories about the league tables of where it's good to die as a company. So doing business is the one that I would be most familiar with. And the UK always does relatively well in that. If you look at how many pence in the pound or cents in the euro a creditor can expect to get back if a company becomes insolvent. And one of the main reasons for that is that the UK is very good at getting money from directors like the German man that you mentioned in that story. Now those kind of legal provisions exist in every single country, but in some countries they exist on paper, but they're not actually enforced in reality. So in Hungary, are those kind of legal mechanisms for suing a bad or a negligent director, are they used commonly in practice, and can creditors expect the bad directors to have to contribute money back to the company so that it can be then passed on to the creditor?
Well, in Hungary, this rule, exists, to be honest, on the paper. Why? Because if the manager would see that there would be an insolvent situation, that he or she withdrawn for the management, and usually, but the Serbian people pointed out the manager. Why? Because then the Serbian people would be liable for this situation. And there is a possibility to invoke the last 3 years manager's liability, but the defense is usually that it wasn't foreseeable for this manager when he withdrawn for the management, this kind of insolvent situation. And referring to the question regarding the UK, people like to move to the UK to die, but not necessarily to die, because in the UK the chance to restructure your business is much higher than in any other European Union states. For example, I only know a Hungarian example. Out of the 28,000 insolvency procedures of last year, only 100 resulted in reorganization. Every other scenario resulted in liquidation. Therefore, there is no chance to restructure your business. While in the UK, there could be the situation you may restructure your business. Not necessary, but the chance is better. It's on your side.
Okay, well, thank you very much.